Good afternoon, friends. My name is Alina Shaltsova. I'm an immigration attorney from New York. And in today's video, we will be talking about individual hearing. It's a very large, interesting topic. I'm going to cover the basics. Well, first of all, individual hearing, this is your trial in immigration court. It means that by the date of the individual hearing, usually 15 days, at least 15 days prior, everything that needed to be done for your case should be already done, prepared, and submitted to court. These are the rules. You can find the rules as to what, when, and how to submit to the immigration court in the immigration court practice manual. It's very important to be organized. Individual hearing, this is a date usually when the judge is going to make a decision on your application. Usually, but not always. Why? Because sometimes, even though individual hearing is going to take place, the judge will need more time, either to check the law, maybe consult with the colleagues, and see if your case, based on the testimony and evidence that you provided, qualifies for asylum. As a rule, your individual hearing is not going to be longer than 2.5 hours, during which first your lawyer is going to ask you questions, which is called direct examination, then a prosecutor and the judge, which is called cross-examination, and then there will be examination of your witnesses. However, very often the hearing is going to be even shorter. Why? Because prior to the hearing, if you and your lawyer were organized, the prosecutor or your lawyer are going to confer, discuss the case, and narrow down the issues for your testimony. For example, you have an asylum case, and maybe the prosecutor is going to agree that you met an exception to 1 year deadline for filing of your asylum claim. Perhaps the prosecutor is going to agree that all you need to focus on is harm that you suffered, or somehow other. The prosecutor and your attorney are going to agree to narrow the issues. So you don't have to repeat the full story, but rather focus on specifics of your story. And if that works out and the judge does not have any issues with your testimony, it is consistent, it is on point, the judge can easily follow and cross-check your answers with your statement. Very often, the testimony of your witnesses is not even going to be necessary, and rather the parties again are going to stipulate that the witnesses are going to testify consistently. So you see, the process can be scary when you are not prepared, and can be much easier to go through if you are and your attorney is thoroughly prepared. Of course, there are exceptions from this general rule. Usually they will be caused by late filing evidence, not prepared prosecutor or your counsel. It happens sometimes that before you begin your testimony, the prosecutor is going to state that they do not have your file, and the judge, as a rule, will allow them to have more time to prepare for the case. Even though it's not your fault, your individual hearing date can be transferred. Many of you who are watching this video will relate to that. What if you have expert witness? Expert witness usually would testify last. So often, just as we discussed with previous situations, it can be stipulated that the expert witness is going to testify consistently with his or her report, and also that the prosecutor agrees that this expert qualifies to be an expert in court. Believe it or not, but not every person who calls himself or herself an expert will be allowed to be regarded as such in immigration federal court. But usually lawyers experienced in these issues are going to recommend someone usually who they worked with previously and who has a very outstanding reputation and who has been recognized as an expert in his or her field of study and work. So if you do have an expert witness, of course, your case may last a little bit longer than the case without the expert witness due to the testimony that extra witness has to present. But I assure you that recently, because the courts became so much more organized and they have the scheduling orders and practice manual telling you when and how to submit the documents, most of the times an expert witness and testimony of your witnesses not even going to be necessary and rather would be stipulated about. These days, most of the individual hearings are going to take place via video. Just like you're watching me right now, you're going to have a screen with different tiles on it, and in each tile there will be a different person. Court, prosecutor, your interpreter, if you're using one, you and your attorney. Sometimes you will be in the same room with your lawyer, but it's not necessary as well. You, if the judge allows, remote hearings can even connect from the comfort of your own home and participate this way in your court proceedings. So as you can understand now, most preparations for your individual hearing are going to take place much before, well in advance to your hearing. And what is it that needs to be done? Well, you will have to, together with your attorney, present to the court all and any evidence that you will be relying on in support of your asylum claim or some other claim, for example, claim for cancellation or removal. You will have to submit a witness list. A witness list gives court and the prosecutor notice as to who you may call as a witness for your case. The witness list also have to comply with Immigration Court Practice Manual. It has to contain names, addresses, and short testimony of what the witnesses are going to testify about, and the written testimony should be always attached as a part of the case. Another important thing that should be presented to court would be bench brief or memorandum in support of your claim. Imagine there are 2.5 million cases pending in immigration court. It will be tremendous help to the court and the judge if you and your lawyer will explain from a legal point of view how you qualify for this or that legal relief that you're asking the court to grant, because otherwise the court will have to do this work. And trust me, court and you will be better off if you are going to help them to do that.